we're in a pub. Hello, how are you?
Very good. Cheers.
Cheers. No, cheers. Absolutely, cheers.
Cheers,
Sarah, cheers.
Cheers.
Sorry, no one knows who you are yet, Sarah. Just we'll introduce you in a moment. We've not done this for a little while, have we?
Pubcast,
yeah.
No, it's been a while.
Yeah. And
we've been to a pub though.
We've been to a pub, of course we have.
That's because we've got a bond.
Yeah, you're my bestie. You are my bestie.
Ever.
Yeah. How are you? How are you keeping?
I'm really good. You had some banter. I've got some better banter.
You've got better banter?
Yeah.
You go with your better banter first.
This is a humongous day for the patent profession.
Is it?
10-day rule ends tomorrow.
Oh, it does? Yeah.
Oh.
Yeah.
What are we going to do? We'll actually have to tell the truth about our deadlines.
I've never really understood the 10-day rule, not being a proper
It hasn't made sense for 15 years.
So what's it about then? What are we losing?
We're losing the fake extra 10 days that you got because it was deemed to take 10 days for communications to arrive with you from the EPA, despite the fact
was that when we used pigeons?
I think it used to come by elephant. I don't know what took 10
over
days.
the Alps.
Over the Alps. Massive bag of office actions and Hannibal. It goes as of tomorrow, and that little lovely parachute we all used to use. Was
it just like a little get out of jail free card then?
Yeah. Well, what you used to do was you used to pretend it didn't exist and say, actually, we've got another 10 days. But then people got wise to it. So we've had to go around the world telling people that cheeky trick has gone now. So you can't
that cheeky trick that they didn't know existed.
Yeah, well, but they all found out. It was the biggest mistake. So big day.
Why's it going? Is it just because it's not needed? Redundant?
It's utterly archaic. The battle they had to fight to get rid of it though, because loads of people obviously hated the idea of losing something.
I've now got a closing question, by the way.
Oh my lord.
Yeah,
excellent.
How quick was that for one?
That's great
in my mind.
Great. I'm going to start preparing for what I think it might be.
You used the word archaic. Just think about that.
Okay. Excellent, good.
Yeah, that's a little prompt for you. But other than that, it's good to be back like in the real world again, isn't it? Because we've been on Zoom for a bit recently, and it's so nice to have you sitting next to me. Last time we did this in the real world, you said you were going to give me a hug. You didn't. I was bitterly disappointed.
I said I'd give you a hug.
You did say you would give. Oh, you know you would touch me. You would touch me. That's what you said.
I can smell you.
Do I smell alright?
Let's move on.
I did have a 10-mile run this morning at 6 o'clock, so it's okay. I did shower.
Lee Davis and Gwilym Roberts are the two IPs in a pod, and you are listening to a podcast on intellectual property, brought to you by the Chartered Institute of Patent Attorneys.
So, should we crack on?
Yes.
Shall we introduce first guest of the podcast?
Yes.
So Sarah Rodriguez. Sarah, hello, how are you?
Hi, thank you for having me. I'm good.
It's so good to have you. So you and I we met not that long ago at Super Congress when I had the great pleasure of introducing you for the case law session there. And I left thinking, we've got to get Sarah on a podcast because she was just brilliant. So here you are. Do you want to tell our listeners a bit about you and who you are?
Sure. So my name is Sarah. I'm a patent attorney. I work for Finnegan in our London office. And I started my career in the US. I was a qualified US patent attorney. I went to law school, and then I moved to Sweden. I was there for 7 years. Yeah, I became a European patent attorney.
Oh, I didn't know that bit of the story. So European patent attorney first? After the US bit?
Yeah. And then I decided I don't speak Swedish, but I want to stay in Europe, and I love a big city, so I came to London, and I've been here for it's probably been 7 years, coming on 8 years. And I became a UK patent attorney as well, so I've taken many exams.
Patent attorney qualification collector then?
Yeah.
I won't be able to say that later on.
It's a trifecta.
A trifecta?
Isn't it?
Is it?
It's European, UK and US.
Yeah.
That's a trifecta, isn't it?
This is just tri-qualified. Are you trying to be too clever?
Tripod. Tripod. This is a tripod.
It's a tripod.
Tripodcast.
God, he's got in early. So, one of the really interesting things we could talk about is your experience of all of those different regimes and how the differences stack up against.
Yeah, so I think for the most part, there's a lot of harmony between our two jurisdictions, but there was definitely some rewiring that needed to happen when I moved to Sweden and I first started training as a European patent attorney. And I would say that's probably with inventive step and added subject matter. Those were probably the two.
Oh, these are Gwilym's most favourite areas.
Is
so
it?
I love those topics.
Yeah, so that was a bit of a shock to the system, I would say. If I had to compare inventive step European to the US standards, the US obviousness, I would say that.
Well, we have a standard in Europe. I think that's
I would say it's quite strict and it's quite rigid compared to the US approach. So I think the main difference there is how we evaluate the skilled person. Mm-hmm. And I think if you were to compare the two, I would say that the European skilled person is like Bill Gates and the US skilled person is like Steve Jobs. They're both brilliant, but the US person is just a tad bit cooler. So basically what I think is that in the US, we give a lot more credit to what the skilled person can do.
Okay.
And as a result, the European or the US examiner can have more liberties in how he makes his objections.
Oh, so because the whole point about the skilled person in Europe is he hasn't got a scintilla of inventiveness. The whole thing is, or he or she, sorry, they haven't got a scintilla of inventiveness. They're just completely unimaginative and have no inventive skill at all.
They know stuff, but they can't do stuff.
They just have a bit of limitations on them. So I mean, if you look at like the problem solution approach, it is quite like strict and very structured. Whereas if you look at the US approach, it's more the mosaic. Look at everything before you, and there's no restrictions on how many documents you can combine, and there's no closest prior art, and you can combine, in Europe you can only combine more than 2 if there's a partial problem, so it's a bit more strict in that way.
That's good though, isn't it? I mean, I should expand on that for you. I think it's very useful to have a framework that is repeatable, because you can predict better.
But what is more realistic to real life situations? Do you think in real life, in a research environment, that the skilled person is following the problem solution approach?
No, and I think the European Patent Office, it's a debate now.
It's a debate.
I think the European Patent Office has pulled it completely away from real life to make it more objective, actually. And I think at trial, the US real approach to actually who is the real skilled person, the Steve Jobs kind of thinking, makes loads of sense. I just wonder about when you're trying to grant 100,000 cases a year,
it's true.
Whether you just want something really repeatable, even if it's not very realistic. But that's
maybe the US takes it too far, and maybe the European model doesn't go far enough, and maybe the best solution is somewhere in the middle.
Mm-hmm. Which do you prefer?
I think when it comes to inventive stuff, it's easier to get around an objection with the European style. And it's more difficult with the US. I mean, especially if you're writing a response with, again, 6 combinations, it could be quite tricky.
So, Lee, you're you're the representative.
I'm the person on the omnibus.
You're the person on the omnibus. Do you want Sarah to give you a bit more kind of background about what the problem solution is compared to the US approach? For the listeners out there who aren't living this day in day out.
You're using language that doesn't necessarily immediately connect with me, so it would be really good to...
Mosaicing, probably thinking, why are there Roman tiles involved?
I do like thought of me being on an omnibus though. The Clapham omnibus.
Yeah, no, that's right. Tiling it. Yeah.
Yeah, I mean, there are a lot of similarities with how you would respond and approaches that you would use, with respect to like teaching away and things like that. And there's no combination of the documents teach a particular feature. But I think it's just the main difference for me is in the U.S. Yeah, the skilled person is just a bit more brilliant, and there's no limitation on the number of references that you can use, and there's no, I guess the structure is not as set as you have in Europe.
So, for example, in classic objection, you'll have your claim for your invention, and the patent office will come up with prior art, which is N documents considered to be relevant, and you have to explain why, given that all of that was in the public domain, you still have an invention.
Yeah.
And the big difference is, and I think, correct me, is in the States, you can have 4 or 5 documents, and you can say, well, you take this bit from that document, this bit from that document, this bit from that document. The European approach kind of says, no, you'd have one document that was kind of the core, what we call the closest prior art, and then you spot your difference and you decide if that difference is in another of those documents. But the EPO, I think normally if you get more than 3 documents, or 3 or more documents, they kind of say it would be quite unlikely for the skilled person to do it.
Let me just check if I've understood that.
Yeah.
So in the US it would be, your reference point is a collage. It's a kind of amalgam.
A mosaic.
Yeah. Whereas in the European system it's an absolute.
Yeah, it is. And both of them struggle from the same problem, I'd say, which is hindsight. Because in the end, the only reason anyone found those documents is because you told them what your invention was. And that's always a bit that's quite... If you think about it, it's all very well having been told what the invention is, to say, well, yeah, but I found 4 documents that...
We should bin the patent system, shouldn't we?
It's just awful. I mean, it makes no sense. No, but and to go back to your really good question, actually, yeah, so I don't know, what do you think happens in research? Do they work from either of those, do they? What do you think?
I would say that maybe the US model is a closer representation of what really happens in research, because I think you have a lot of cross-disciplinary collaborations going on, and I think it's not in the real world. It's not as restrictive. You're not thinking of the objective problem and then partial problems and things like this. But yeah, I think it's an interesting problem.
I have to say, having seen loads of different ones, and we'll get into the UK in a minute. Sorry for pointing. I can point in.
No one can see you.
I know. On Zoom, no one can see you.
But you were literally pointing with a pen then, which I always find quite rude.
I'm excited. Well, this is such a cool topic. I still quite like a repeatable, even if slightly unrealistic one, just in terms of the administrative role of getting all those patents granted. And I have to say that clients get very frustrated in my experience with the US approach, because every time you think you're there, a new document appears that's added.
Shifting sands?
Yeah. They keep adding new documents and saying, oh, we'd add this for that document. What do you think about that?
I mean, that happens. That does happen. But there's always arguments. You can apply the same arguments in Europe that you do in the US. I mean, there's no motivation to combine. It's in a different technical field. So a lot of the arguments are the same. It's just the framework is quite different.
So we've got we'll move on from this in a minute, but we've got the problem-solution approach in Europe. Closest prior art, distinguishing feature, technical effect, formulate the problem, is it obvious to combine something else. In the US, is it teaching suggestion motivation thing? Does that still exist, that test, or is that gone?
So teaching suggested motivation, that's the language that's often used.
Yeah.
But mainly it's looking at all the references as a whole, and would the skilled person be motivated? What would the skilled person be prompted to do based on all the references together? And
then, of course, you got your third qualification, the UK one. Do you find yourself ever comparing the UK approach to inventive step? Or?
So in the UK, I do European practice, so not so much UK responses, but mainly my main focus is European practice.
Yeah, because for me, the UK approach is governed. Well, of course, it's governed by what the courts say you have to do. But the courts have this unrealistic approach to it, because they always have a very expensive expert in there. In fact, they have two experts who both weirdly happen to agree with their own side's case. It's always a.
We do have an expert in the UK, don't we? I mean, there is even an institute of expert witnesses.
Is there?
Yeah.
Are they part of the MEMCON?
I don't think they are.
Oh, that's fine then.
So you probably can.
They
certainly didn't vote for me.
We have a guest.
Sorry. But I would say another main difference is probably added subject matter. And I think in that area, a lot of the US attorneys are kind of looking out to Europe and thinking, like, what's going on there? It's a bit strange.
Oh, come on, explain added subject matter to me. Consider me someone who knows nothing, which is largely true.
Normally works.
So if I were, if I were to have an image to describe the two, the differences between the two jurisdictions, for Europe, I would have maybe an old English gentleman smoking a pipe, and in the US, I would probably have a young teenager smoking a joint. That's probably like a good comparison of the two.
There's a lot of parallels here, but yeah, go on.
I think I passed both of them on the way in. So.
But I think the main difference there is, again, like, what can the skilled person do, and what are we giving credit for the skilled person? So I think in Europe, it's even though you're not supposed to have, technically the statute doesn't require literal support. A lot of times the examiner will require literal support, whereas in the US it's much more relaxed.
Oh yeah, it is. And again, which you prefer? What do you like?
For the patentee, I think the US model is a bit better.
I agree.
So it's a bit more forgiving.
And for the third party?
For the third party, definitely, the European model is going to be better. But as a patentee, the US model is more forgiving.
So this is all to do with how much information you can add to a patent application after filing, because we're always rewriting the claims to deal with objections coming up from prior art in the inventive steps section of this discussion. And in the States, what is the actual test? I mean, what is the test in the States? I'm not aware of one.
So if it's directly and unambiguously, so that's
it's very similar sounding.
Yeah, so it's basically what can the skilled person derive from the application? Is it within the?
And so that's Seth Rogen smoking a joint. So that's in there somewhere.
Who's Seth Rogen?
I like your mental images of people. I love your mapping of the.
Is it a young person?
He was.
Oh, okay.
Is he still young?
He's getting old.
Defamatory as well. No, it's just such a mess. And we've got Tolkien over here smoking a pipe.
Oh, I know Tolkien. Yeah.
So the point being that somebody's a bit more. It's just more kind of a relaxed attitude towards it in the States.
Yeah.
So the debate there is, it's a really interesting one. The EPA has gone too far, I think. It's very, very strict. So if you put some stuff into your patent application at the beginning and you decide that some of it's really important, you want to pull that out and put it in the claims. The problem is that the EPO is quite likely to say, well, that exact combination of ideas and concepts wasn't there, So it is really tricky, isn't it, in terms of getting it through.
So the US, that's one major difference. The US isn't so strict with the different combinations.
Right.
So in the EPO, there's case law saying that your application is not a reservoir of different features, that can be combinable at will. And I would say in the U.S. there's no direct case law on point corresponding to that. But I would say it is more likely to be a reservoir of features that you can combine at will.
And there's a case, I think, just come out in the UK, isn't there, from Haken about this? This isn't a test, I only literally saw this the other day, but I think the UK courts may have just jumped out and said, actually, we're going to go more European now, which is... So the debate there is about who you benefit. The patentee benefits from having more latitude from the joint smoking teenager about what you can decide your patent should have meant if you'd written it right in the first... have a patent, man! Whereas you got in the UK, in Europe, it's much more, you didn't say that explicitly, you're making it up. So the patentee, like the US system, third parties don't know what patent's going to get granted in the States because you can't work it out.
Can I ask an entirely random question, which is in my head at the moment, but I tend to do this. So on a big policy level, we're quite interested in patent law harmonisation. Yeah. And what we've talked about here are some really deep differences in 2, maybe 3 jurisdictions. Mm-hmm. What hope is there of ever getting any harmonisation if there are these inherent distinctions?
It's a really good question because, of course, the tests can sound the same. In fact, the way you just expressed the US test is basically the same as the European Patent Office expresses the test for added matter, directly and unambiguously derivable. So it's the interpretation of it. I think another topic I wanted to actually raise with you, Sarah, in terms of the differences, is the operation of the patent offices, kind of the procedural level. So, for example, let's start with an interesting one. EPO is a career, and it's a life career, and it's a very nice place to be. There are pressures and tensions, but there's some real perks to being an examiner. The States, it doesn't seem to be, there are so many long-term career examiners. I've heard that people come through and then move on.
Yeah, so I think the European patent attorney as a profession, it's a much more competitive job. Right. And when you see the examiners, a lot of them have PhDs, and I think they're better compensated and they have better perks. Whereas in the US, I think the compensation is not as good as it is in Europe. So I think it's more of a stepping stone. A lot of people join the USPTO and then maybe move on. Yeah. So it's a bit different.
And that's problematic, isn't it? You lose that continuity, you lose the building and the passing on of experience.
Yeah, I think so. And I also think that the European patent attorneys have more time with the case, whereas in the US, a lot of times, especially when I was there, this is many years ago, but when I was there, it was we would often have an interview with the US examiner, and a lot of times we would just spend the first few moments of that interview on the phone, just explaining what the invention is, going through the claims, and going through the figures, and just making sure that the examiner is on track. So there's a bit of a difference, whereas with the European examiners, I don't find the need to do that as much. So, this isn't the case for all. There's a lot of brilliant U.S. examiners. Obviously, it's not the case for all examiners, but there's a slight difference with compensation and things like that.
I think that churn's a problem as well, doesn't it? Because I think you don't get the institutional knowledge building up as a result, maybe.
Yeah, but also there's, I guess one of the things that strikes me, and I've always been interested in this outside of the world of IP, in terms of people who are in jobs for life. You do get that potential, don't you, that knowledge stagnates. Because you don't get that kind of movement of new people coming in who are perhaps more up to current trends and stuff like that. So I think it's I guess the American system, where you do get people using it as a stepping stone to something else. You use their brilliance for a while.
Yeah. It's interesting. So we talked about two of the biggest jurisdictions. I think we'll probably get told off for saying they are the biggest jurisdictions. But you've got IP5, you've got US, EPO, Japan, Korea, China. Yeah. They do kind of lead the way, actually. And it's interesting, isn't it, how internationally, globally, you see people aligning with one of those two systems. The US system seems more popular to align with, I think, around the world maybe than the European system. I'm not sure. What do you reckon?
Who do you think the US system is aligning with, or who is aligning with the US system?
I like the fact you get questions back. This is brilliant.
No, hang on a minute. Whose podcast is this? Actually, I'm thinking I might have to retract what I just said. Maybe Korea? I don't know. I don't know too much about that.
I'm not too sure. I'm not so familiar with the Korean Patent Office.
Yeah, I don't know, but I know that the Germanic system is very popular, in particular, not just the EP system, but specifically the Germanic system. And to go back to your point about harmonisation, Lee, it is really interesting. In terms of somebody running a portfolio globally, those differences are really significant, though, because you've got one invention that's going to be, looked at by, Bill Gates in Europe, Steve Jobs in the US.
We really could have done with kind of finding a European person, not Bill Gates, couldn't we? I'm a bit disappointed that we've got Bill Gates. I don't know, but let's go with it. Yeah.
John Major. I think John Major is Britain, Bill Gates. That's my next defamatory statement.
Yeah, and I remember his operating system so well.
But there's definitely things that I do when I draft an application, for example, that I don't always do what they told me to do back in the US, and I don't probably follow what the typical European patent attorney does, just to like kind of account for these two differences. And I think one of the things that I do is not having the stating the problem in the background of the application, and I feel like a lot of European patent attorneys get very upset by this.
Yes, yeah.
It's really difficult for them because there's no requirement to actually put it in the background. I mean, you can put it in the summary, or you can put it in the detailed description. But that's one of the things, because I think because of the EQE, that's kind of like they're like horrified, like no, don't do that.
Don't stop. And the EQ is a brilliant ruse by the EPO to brainwash the entire patent profession. And it's succeeded enormously well. So well done, EPO.
Controversial.
No, it's just, they know that. They know that. It's interesting, isn't it? The systems are harmonised. The tests look harmonised. The application varies from different countries. Yeah. I've got a great question for you. It's quite difficult. Don't you dare bounce it back.
Okay.
I've already spotted no trick.
No, please do that. I've loved it. This is proper advocacy.
Do you think that we all agree, strip out the test and kind of apply the underlying principles? Do you think let's start EP and US. Do you think they basically agree on what an invention is? Would they agree that the same basic concept was the inventive thing, or do you think there's a risk that they might actually disagree fundamentally about what the invention actually was, based on those two tests?
I think that, well, if you take the example of business methods, so in the US, that's much more easily done, whereas in Europe, it would be much more difficult. So I think in some areas, I think there are differences in what the US and Europe consider to be inventions or patentable, for sure.
That's a great answer. I think
you're thinking. Again, you are thinking.
The whole plan.
I can smell that you are thinking. I'm that close to you. Yeah.
Together.
Intellectual pheromones.
That's interesting, isn't it? I think that's also kind of the more entrepreneurial kind of US spirit to a certain extent, saying, "Hey, you came up with a great idea, have a patent," kind of thing. Whereas Europe is very restrictive in that kind of area. Moving aside from the debate about what should or shouldn't qualify as a patentable invention, if you've got the same concept, you'd think, kind of almost at the human level, that we'd all agree that looks like.
You would think so, wouldn't you?
Yeah. And maybe that's going to your question about global harmonisation. Maybe that should be the test. One day, something that a bunch of people on the bus agree is a good invention.
Because it seems to me that when we talk about harmonisation, we're looking at systemic stuff. We're talking about a grace period.
Yes.
Yeah. We're not talking about invention. We're at the level of systems and processes, and not at the level of kind of intellectual capacity, if you like.
Yeah. No, I totally agree. I think harmonisation is about agreeing that we have novelty and the non-obviousness to invent a step, and harmonisation is about agreeing that we have a test for added matter rather than the specific application. One point, though, I think it's really important for harmonisation is a harmonised approach to the balance between the patentee and the third party. Going back in particular to both these topics, inventive step and added matter. And it's interesting that perhaps it's skewed a little bit more to the patentee in the US and a little bit more to the third party in Europe on added matter. Oh no, on both actually, yeah. So the US is more skewed towards the patentee than to the third parties, possibly on both, which is an interesting point of view, perhaps.
I think for inventive step, I would say that it's more skewed towards the patentee well, I don't know actually. In some instances, it's easier to get around an inventive step objection in Europe, and in some instances, it's difficult. Okay. Like, for example, in Europe, when you consider inventive step, if the examiner, if he determines that there is limitations that aren't technical, they'll just be removed from consideration in an inventive step, whereas that doesn't happen in the US. Mm-hmm. So I thought that was something that was quite weird when I started training in Europe. So that makes it more difficult, I would say, to get around.
But we see, well, if you ask an American attorney, and I'm hearing more and more that the US Patent Office is beginning to be considered to be anti-patent, or the systems, because of the re-examinations and the other thing, IPRs. Yeah. Is that, do you think that's right, that it's getting tougher?
I think everyone describes it as a pendulum swinging.
Right.
So it's always going back and forth.
Where is it now?
I have to think about that. I'll have to think about that. Where do you think it is?
I'm here.
I'm loving this.
Stop it. Wait till you get to your question to me. What I'm hearing is from two different points. In fact, that podcast the other day that came up as well about how, to a certain extent, it's getting more difficult and it's less attractive to get patents now. So you got the whole IPR thing, was it inter partes review or something?
Yeah.
Yeah.
So it's basically a bit like your opposition.
Sure. So you can attack a patent in a way that wasn't so easy before.
Yeah, gotcha. Yeah.
Plus, the courts don't give injunctions ever, I think, or something like that.
I mean, I think IPRs are a positive thing because it's a way of doing maybe a mini litigation for a lot less money.
I think so, but I think it's being used as support for an argument that it's a bit more anti-patent in the States as a result because it's just easier to attack them through that. And I think then you add on the ingenuity of US lawyers who can make anything complicated brilliantly. And that's a good thing. That's their job. They're doing their job. But also the court's not very keen on giving out injunctions as well. So. And then, of course, we then heard, however, there's thousands of litigations a year in the US, and 89% of them are by non-practicing entities. I remember
Trolls.
Yeah. So they obviously think that the system's okay for people with patents. So
yeah. Can I come back to the systemic thing?
Yeah, do it.
Because only because it's so important for us at the moment. So with the UK acceding to CPTPP and all of the work that we've done there around ensuring that our place in the European patent system is protected and preserved. Central to all of that has been the conversation around a grace period, and yes. I'm conscious, Sarah, that you've worked in systems with and without a grace period. So I would just like your view on whether. So CEPA's position is quite clear on this, and that's that we're entirely neutral on whether there should or shouldn't be a grace period. Just that if there is one, it needs to be part of a harmonised package globally. So come on, in terms of the systems, where are you on grace period?
I think it's very patentee friendly. I think it's nice to have a grace, especially for patentees who aren't very patent savvy. I think it's generous and it is quite nice to have a grace period. And there's other countries who have grace periods as well besides the US. So
yeah, so as a non-patent person, I've been doing this for 12 years, so I know a fair bit about it.
Yeah.
But when I try and describe this to friends in the pub who are really only interested in football, they can't believe that if they were having a chat in the pub to someone and said, I've just thought about this great thing, it's gone. They can't get their head around the fact that you can't disclose anything at all. That seems inherently unfair. So I guess for the person not quite on the Clapham on the bus, not on it yet, they would think that they should be able to talk about stuff that they're doing and not.
That's a really interesting insight. I mean, I think what's become really clear is actually the European non-grace period system is actually the anomaly, and as you know, the US has got it. But actually, if you start looking around, very few jurisdictions don't have some form of it. Different levels of rigour.
Isn't it just a safety net? Isn't that all? Deep down.
Without being a bit rude about your mates in the pub.
Oh no, please do. I don't. I need to qualify. I have no friends. They are just people I know and I drink with.
I think for me, it's the system does need to. You need to work out where the system's aimed at. It's to stimulate innovation, but to balance the interests of the patentee and third parties, which I'm fascinated by, as you may have guessed.
Yeah.
But it's also. You've got to look at who it's aimed at if you're stimulating innovation, and the sad fact is that the individual inventor is going to struggle in the modern world, not really to get an invention, but to get anything out to market.
Yeah.
And frankly, all the easy ideas are probably gone anyway, which is I think it's true. Challenge me, I don't know. I think any SME or business is a bit bigger who's looking at innovating and looking seriously at getting patents.
So they're kind of like the micro.
Yeah, exactly.
Yeah.
Maybe 30 plus years ago, it was a bit tricky to find out what the rules were for patenting.
Yeah.
It's not difficult now. You can immediately find out some of the basics. So my problem with grace period, I do think it provides a safety net and it's helpful in that way. But actually, I worry that it sometimes encourages that kind of unprofessional behaviour almost, in the sense of people not just doing some basic due diligence. Maybe that's a bit mean of me.
And thank you for that. It was really interesting. I did actually ask Sarah though, not you. So
she was only going to ask me anyway. I mean, she said, "What do you think?"
It's lovely.
Sorry,
it was lovely.
Sorry,
Sarah, what do you think? Yeah. Do you agree with him?
Yeah, I do agree. But I think mainly I think it's a positive thing. And I think it does help innovation, and it does provide an opportunity for startups and inventors who don't have a lot of.
It sort of seems inevitable, doesn't it? it seems inevitable.
Oh, it's going
we're
away.
gonna get there,
Yeah. We're a team, by the way, so you can ask.
Okay. Yeah, I feel like an outsider now.
No, is it? I think what is inevitable is you're right. I'm not saying anything. I can't speak now.
Sorry, I must stop looking at you.
No, it's getting weird.
Sarah, so I'm conscious of time. We've whizzed through this really, really quickly, but there might be other stuff that you wanted to talk about. So you sat there thinking, ask me that question. Is there a question you really want us to ask you?
No, I think you covered it. Yeah, if there's anything else that you'd like to...
I've got one more.
Go on then, you go
So
first. Because obviously I have a closing question and I'm really desperate to get there.
Out of interest, you talked about these multiple qualifications. In terms of the rigour of the different tests.
Oh, great question.
How have you found the contrast? Pretty unique contrast.
So I think, so there's a US patent bar in the US, and that is quite an easy exam. That was probably the easiest. But there's the US state bar exam. And I would say that's very difficult because you have to. It's a closed book exam, and you just need to have knowledge of law of. I think it's about 13 different areas of law. So that's a bit. It's a multiple choice test, and then there's also an essay component for the different state that you're part of. Then there's the EQE open book test, and then you have the UK exams closed book test. And I would say that with the EQE, that's more difficult in some ways because you can be asked to calculate a fee because you have an open book exam and it can be like quite detailed. Whereas in the UK, it's it's a closed book exam, but it's I think the infringement paper could be like that's quite like a difficult the validity. That's quite a difficult paper. So, but it's good because I think of all of them, that's probably closest to real world situations at UK exam, so that's quite good.
I guess that's what they're designed to be, isn't it? So quite happy to hear that actually.
I've got thoughts on that too. Anyway.
It's not your podcast.
I know.
Share your thoughts, please.
No, you can't keep doing that. So you obviously love exams. What exams are you taking next?
So I do have to take the driving exam.
Wow.
I have to take the practical test, So, and hopefully that's the last exam.
Oh, right. That's quite difficult now, isn't it? You've got to
I think it's much harder here than it is back home, for sure, definitely. So, and I have to learn how to drive on the other side of the road, which is difficult too.
So you have to take a test because you've not qualified anywhere? Or?
No, so I do have an American driving license, but you can only use it for a year, and then you have to do everything over again. So I'm doing it again for the second time.
I'm not unlike Neil over there. I've done the speed awareness course actually, and I still don't know. It's some speed limit that's based entirely on how far apart the lampposts are or something. I don't really get that.
Exactly.
No? It was a while ago. I remain unaware.
That worked really well then, didn't it? Yeah. It's nice to know that the judicial process in the UK when it comes to driving offences works. Sarah, thank you so much for giving up your time to come and talk to Gwilym and me in the pub, which has been amazing. So we have this little thing where one of my jobs, so I'm kind of like the elephant in the room always, aren't I? I can ask silly questions, and also I can do like a closing question. I always try and make the closing question something to do with something that's happened on the podcast. And right early doors, you said about getting rid of the 10-day rule because it was archaic. So I would like you, Gwilym, to cast your mind out. This can be professional Gwilym or personal Gwilym. Mm-hmm. Yeah? Is there anything else archaic that you would like to get rid of in your life? It's coming your way next, Sarah, so you need to think about it.
I'll talk slowly to give you shoelaces.
Shoelaces?
Absolutely ridiculous. I swore blind by the time I was 20 that shoelaces are a thing of the past. We'd all be having Velcro by now. Why are we still wearing shoes?
Because you would look like a baby.
Completely no.
You would look like a baby.
I'm not being archaic. You're being archaic. I'm being futuristic. Velcro makes so much more sense. Shoelaces are fiddly little things. They go undone when you're not expecting it, and then they drag in the rain and the puddles, and you've got wet shoelaces. I've got some buying in over here.
So this is a bit room 101ish now, isn't it?
Yeah.
So you are getting rid of shoelaces into the archaic bin of history.
Exactly what I'm doing. Shoelaces.
Sarah, it's your turn. You can't ask him. or me.
What would I get rid of? Maybe the HMRC helpline. Actually get rid of that. That's quite difficult. Probably have a different way of contacting them. That could be quite painful, yeah.
Oh, that's awful.
You got some tax problems.
No, but just if you have any questions for them, they're difficult to get to.
Unless you have a son who happens to be a forensic accountant in HMRC and you can sort of like just drop him a text and he
That's
sorts stuff
quite
out for you.
useful, the
Yes,
replacement.
I am blessed in the sense that one of my
Has
sons.
he got an inexhaustible supply of Velcro as well?
No, he hasn't.
I like to bring these things together. Lee?
Yeah, so I was thinking about this quite carefully, and probably more carefully than I normally think about things. Because obviously,
in your defence, you think. You're a thinker.
Obviously, I've had the time, haven't I? Because kind of we've
Yeah,
gone through the podcast,
as usual.
and I got this question really early, so I know exactly where I would go with this. Okay, so I would get rid of revolving doors.
Ooh.
Because I don't know what purpose they serve other than to cause me to go round continuously before I work out how to get into a building.
Does this happen a lot? We've got them in my building. We've got CCTV.
It happens more than it should. What's wrong with a good old air curtain that's kind of just continually kind of okay, might not be sort of for the best thing to do for the...
When did you last go somewhere with an air curtain?
Star Wars. All shops used to have, and stuff used to have air curtains. Now, no, I have to go around in this spinny thing until I can work it out. So I would get rid of the revolving door.
I had two friends once, and they would look to try.
Yeah, you had two friends once, so you got none now.
More than you've got, apparently. And they were trying to be quite cool, and they went towards the same revolving door, but they went to each side.
Oh no!
That's brilliant.
Yeah, no, revolving doors. Gone. Sarah, thank you so much for... there's no other way to do that other than just quickly cut to the closer, is there? Thank you for sharing your time with us. I will say again that Sarah was at Congress and was one of the star turns looking at case law, which was just absolutely brilliant, so thank you so much for that. Thank you for coming on the podcast. You're waving your pen at me in a very scary
Quick shout out. Finnegan, say hi to Tim May for me. I saw him a week or two ago. You had a big thing, didn't you? Say hi to Tim, old friend of mine.
So I'll see you on the next one, which is in about 20 minutes' time.
Or 2 pints.
Or 2 pints, yeah. Thanks, Sarah.